Get ready, start. The Madhya Pradesh High Court recently refused to interfere with the decision of the trial court to add charge for offence of murder punishable under section 302 IPC against the accused after the injured person died 13 days subsequent to being discharged from the hospital. Stop para. The cause of death being said to be septicemia, the court observed that the offence of murder cannot be ruled out at the stage of framing of charges. Stop para. Rejecting the contentions raised by the petitioner oblique accused, the bench comprising of Justice Sanjay Dwivedi observed, in my considered opinion, the trial court did nothing wrong because it can very well form an opinion at the time of trial or after conclusion of trial whether offence under section 302 is made out or not. Stop. Taking note of the law laid down by the Supreme Court in the case of Virla Satyanarayan Supra, wherein the Supreme Court has held that if death is caused due to septicemia, offence under section 302 of IPC is rightly made out, I am also of the opinion that the order passed by the trial court does not suffer from any patent or material irregularity, and at this stage, it is not proper for this court to interfere in the same or to form an opinion that the offence under section 302 is not made out against the applicant. Stop para. Facts of the case were that a FIR was registered against the petitioner for offences punishable under section 294 Obscene Acts and Songs, 333 voluntarily causing grievous hurt to deter public servant from his duty, 353 assault or criminal force to deter public servant from discharge of his duty, and 307 attempt of murder of IPC. Stop para. However, 13 days after being discharged from the hospital, the injured person died due to septicemia. Stop. Considering the said development, the trial court charged the petitioner oblique accused under section 302 IPC and section 25(1)(b) of Arms Act along with the other offences mentioned in the FIR. Stop para. Aggrieved, the petitioner filed the revision petition to challenge the legality of the order passed by the lower court. Stop para. The petitioner submitted that the deceased was discharged from the hospital after the doctors had concluded that he had suffered a simple injury. Stop. It was contended that since the injured person died later due to septicemia, the same ought to be attributed to negligence on the part of the doctors who had treated him earlier and not to the petitioner. Stop. Therefore, it was argued that the offence under section 302 IPC was not made out against him. Stop para. Per contra, the state supported the order passed by the trial court by submitting that the cause of death shown by the doctor was septicemia, which admittedly got developed owing to the injury caused by the petitioner, and as such, offence under section 307 IPC was rightly converted into section 302 IPC. Stop. It was further argued that it was just a charge levelled against the petitioner and that he could challenge the same during the trial. Stop.